Welcome to Monroe County Public Library. Tonight we are very lucky to have representatives from IU's Maurer School of Law's Intellectual Property Law Clinic to discuss copyright and how it might affect you and your digital creativity projects. And we're just going to go ahead and get started, and we're going to have talks from Paul, John, and Gerald, and here's Paul.
Hello, everybody. Okay. If I get this. You can tell that I don't have a Mac. All of this. This is no good. Oh, great. So I have a different display up here. So today you guys are going to hear from a few of us students at the Maurer School of Law, as already indicated, and also our professor, Mr. Norman Hedge, who oversees the clinic. Today we're going to be mostly talking about copyright law and its permissive uses, which is known as fair use. We're also going to talk about the possibility of infringing on someone else's rights, or the possibility of somebody infringing on your rights. Ultimately, most of you are probably here to get right to the point on whether or not you can use someone else's copyright. The answer is, well, maybe, yes, kinda, perhaps no, but we'll get to that. Hopefully we'll help you be able to work that out for yourself. So what is intellectual property? The umbrella under which copyright falls. Intellectual property, in a nutshell, is a work or invention that is a result of creativity. Basically means you as a creator have came up with something of your own, maybe through use of something such as a pen and paper, or a music instrument, etc. Where this right comes from is our United States Constitution. Article 1, Section 8 of the Constitution, in the original draft, gives us this right. This lets you know that our founding fathers knew the importance of intellectual property, that they would go as far as to ensure that it's in your Constitution. While some may speak about First Amendment rights or Second Amendment rights that came after the fact, your rights to intellectual property already existed in the Constitution. It's important to note that most, maybe not most, I'm not sure, but much of the world's wealth is based in intellectual property. For example, recently, Facebook has a certain worth attributed to it. That worth is somewhere around the hundreds of billions. But as far as actual tangible assets, it's only about less than $50 billion. The rest of that is due to intellectual property that doesn't actually go on a balance sheet since it's an intangible asset. So, what is the copyright protection? It's an exclusive right. We call them a bundle of rights. This bundle of rights give the owner the right to dictate who can publish or distribute their work. These rights can be sold to other people, just like how you would sell any other property. You could even limit how long they can use your right. For example, we all know that or may have experience going online to something like maybe Pandora, etc., where you may have a subscription to use online music, and you pay for a certain pay to use their features for a certain duration. So they have limited your access based on your ability to pay them or how much you pay them. The protection comes under the U.S. Copyright Act, which basically says that any work of authorship, once it's fixed in a tangible medium of expression, is protected. The word tangible is kind of like a work of art in that it could be argued about whether or not that medium is actually tangible. For example, when we think about copyright in music, what are we talking about? Are we talking about the CD itself? Or are we talking about the music that's on the CD? My copyright is in the music. The tangible item is the CD itself. Similarly with a book, like people say they have a copyright in a book or they wrote a book. Well, the book is just the tangible medium of the expression, the paper. Well, I'm actually want to protect my words that's in that book. When can you be protected? I just mentioned that. Often people may ask, since there's a federal protection, do I have to register to work in order for it to be protected? The answer to that is no. It does not have to be registered in order to be protected. However, it's encouraged to register your work to protect yourself from that work being infringed on. Because once it's registered and a person infringes your work, then you can actually, if need be, get damages, which is basically amounts to having somebody pay you if they infringe your work, if it's registered. If it's not registered, then you would probably, at best, be able to get them to cease and desist, desist from using your work. Basically means that you get get a court to say, stop using my work. But you don't get any, may not get money in the form of damages if it's not registered. I've already mentioned that if it's registered, you can get damages, but you can also get what's called statutory damages. And some bodies of work, such as in movies, for example, oftentimes when you watch a DVD, a disclaimer will pop up on the screen that says, hey, look, due to the Copyright Act of whatever, usually 1976, and then it'll give you a price which says, hey, look, if you copy this movie, this statutory damage is like $200,000 or something ridiculous if you was to do that, right? As a warning, that's a statutory damage, which means that, hey, if you found in a court of law to have copied this movie, this is the price that you may end up paying. Is it really worth saving $8 from not buying the DVD yourself? In the court of law, that registration is known as prima facie evidence, which basically means that when you say prima facie, that's a fancy legal term that basically means that the burden is kind of shifted on the accused person to prove that they haven't infringed your work, since they were on what's called notice. Your work has been registered with a federal agency. They should have known or knew that your work was protected, and since they infringed on it, or at least you have a prima facie evidence to prove that the burden is shifted, they will have to overcome that, rather than you have to do it the other way, which is mean like you will have to prove it. They will have to kind of disprove that they used it. For the general population, when you're using somebody else's copyrighted work, there's certain ways that you can do so, which are permissive without reaching a level of infringement. And in academia, it falls under the following 5 categories. Usually, people will come to us regarding scholarship, and they'll say, can I use this, can I use that, can I use a photo from somebody else's book or some music that another person has prepared, etc. And we'll do an analysis, and then we'll go based on this. We'll say, well, okay, have you attributed the work to the person that created it? Basically meaning that you gave credit, like, hey, look, I got this picture from this newspaper, from this source. Then you have what's called plagiarism. Most people know what that means, which is to use somebody's work without attributing it, without saying where it came from, without putting the source of that information embodied into your documentation. Then infringement is using somebody else's work that's protected without their permission. Licensing is what I referred to earlier when I said that basically you pay somebody for permission to use their work. And then fair use is basically when you use somebody's work without necessarily worrying about infringement. There's certain times when you use a person's copyrighted work and it could almost never be considered to be reaching a level of infringement. John will explain that in a little bit. So, since this is a form of academia, we're at the law school and I'm the teaching thing, I want people not to be confused on the standards in law and equate that to what they see in the university setting. What people may not realize is that were you at a public library or a university, et cetera, there may already be agreements in place with those entities with the copyright owners that give that university access to that information, and you as a student or user of a public library may have access to that, but that does not necessarily mean that the copyright owner wants you to use their material in your own private setting. So for example, at the law school or even the university writ large, we may have access to get information online from protected sources. And since it's there, you're going to use it and maybe even abuse it a little bit. But I can't go home and expect that I'm going to have a free subscription to whatever that service was, or that I can use it in my own way. Like I cannot just take it in large chunks, print out all their work, and then I have, without paying for a book, for example. The purpose of this particular class is people may be interested in using electronic methods to get to copyrighted material. You ought to know that something exists called the Digital Millennium Copyright Act, which basically means that your online service provider ought to let you know that, hey, look, we're giving you access to the internet, but that doesn't mean that you're allowed to download a whole bunch of information. The act in general actually exists to protect the provider in case people do use their services to infringe, but they're at least supposed to warn you ahead of time, hey, look, we're giving you access to the internet, but don't download a whole bunch of material. Don't just start downloading movies since we're providing you this access. I think maybe the library may have something like that as a disclaimer on their, when they allow people to use their internet. I'm not sure. So what is infringement exactly? I'm sorry, you want to begin to explain? All right. So Gerald would go into detail now on that.
So now that you know what a copyright is, I wanted to talk just a little bit about infringement. Infringement is the bad word of intellectual property. especially in copyright. You don't want to find yourself involved in an infringement situation because it causes problems for you no matter what side of an infringement you're on. If you're a owner of an original work, an infringement will cost you time, money, and energy to go after someone who's infringing on your work in order to enforce your rights. And on the other side, if you are someone who happens to infringe on the rights of a copyright holder, it could cost you money. And it could be a big problem for you as far as being involved in litigation. So what is copyright infringement? There are two elements involved. There has to be an ownership of a valid copyright in the work. And there also has to be a copying by the defendant. These are two necessary elements. They work together. One will not be sufficient. So the defendant must have taken an improper amount of the plaintiff's work, and this is known as a requirement of substantial similarity. So say, for example, if I come to you with my guitar, and I say, I have this brilliant idea for this wonderful song I've been working on. I haven't written it yet, but it's been in my head for a week. Let me play it for you, right? So I sing this song for you, and you immediately run off and record that song. Is that infringement? No. Did you make a copy of my song? Absolutely. So there is a copy, but there's no ownership of a valid copyright in a work, because my song that I expressed to you was simply an idea. As Paul explained, I didn't write it down in a tangible medium. It was just something that was floating around in my head. So these two elements are necessary. They go together, and one is not sufficient. Even if the works are substantially similar, the requirement of copying has not been met if the defendant's work was independently created. So, another example, say you're in Bloomington and you're working on this great poem, and I'm back in my home state of California, and I just happen to be working on a poem, and it just happens to be the exact words that you wrote. Mine is exactly like yours, but we've never met. I don't know anything about your poem. You don't know anything about mine, but our creations are similar, right? So even though there's a substantial similarity between our works, it's not a copy because you didn't know about mine and I didn't know about yours, right? So the copying element doesn't exist. Therefore, it's not an infringement. Circumstantial proof of copying is allowed by the courts. It's very rare that you would find someone actually doing an infringing copying, say walking into an art museum and actually tracing over a painting, and you can find evidence of someone actually copying a work that has copyrights. So the courts have accepted circumstantial proof of a copying as evidence, and that requires an access to the copyrighted work and also a probative similarity to the work. So you would have to prove that an infringer had access to your created work, copied that work, and that proof would be resulted in the similarity of their work to yours. So in the example that I gave you about the poem, I had no access to your work. We were in separate places. We just happened to have the same idea. But if you were in a recording studio and you were recording music and I had access to that music, I overheard what you were playing, I overheard what you were recording, that access is proved. And if I go on my own and record something that's probatively similar, substantially similar to yours, then that could serve as circumstantial proof that a copying occurred, and it would be evidence for infringement. There's also contributory infringement. Say I don't do the copying myself, but I encourage someone to do the copying. I supply someone with material to do the copying. I say, well, you can use my recorder to copy that music. You can use my computer to illegally download that music. Then I may be liable as a contributor to the infringement. It requires actively inducing the infringement or knowingly supplying the means. So some examples of infringement that occur all the time. I walked around the library for a little while before I came in, just to kind of get a feel. It's my first time being in the library, so it was a good experience. But there were several ways that I saw that infringement could occur even in the library. In the book stacks. This is all copyrighted material. This is material that can be copied by photograph, by photocopying, or even just by writing in a tablet word for word copyrighted material out of a book. At work, a lot of employers have copyrighted material, whether they be practice manuals or employee handbooks, any of those type of things that are copyrighted works owned by the company. If you copy them without authorization from the owner, you could be liable for infringement. Anybody in here have a cell phone? Anybody? I have a very old phone. I have an iPhone 4S. And I promised myself after this semester, I'm going to get a phone that at least brings me into this decade. But I use my phone for all sorts of things, and the cell phone can get you into big trouble when it comes to copyright infringement, especially these smartphones that have all these capabilities with different apps and whatnot. One way you can get into trouble with the phone is with the camera. I mentioned some of the books out there. I've been in the law library and at times have gotten tired and said, look, I'll read this material later, so let me just take a picture of a few pages, right? And I'll pull it up on my phone at a later date and catch up on some things. I don't feel like staying late in the library. Well, did I make a copy? Was it a copyrighted work? Did I have authorization from the copyright owner? I may have infringed. Another thing, anybody like sharing memes? I have tons of memes on my phone. Sometimes I like the ones with photos, but I didn't take the photo. Someone else took the photo. Someone else holds a copyright in that photo. So if I download a meme, did I copy it? Did I have the permission of the copyright holder to copy it? I may be infringing. Same thing with video capabilities. So these are all ways that these little devices in our pockets can get us into big trouble if we, one, copy a work that is owned or possessed by a copyright holder, has a legal copyright in that work. And now John's going to come in and talk about fair use.
All right, whenever somebody's doing something they feel like they shouldn't, they usually respond by saying, "Oh, what I'm doing is fair. It's not, taking money away from somebody. It's not ruining it." They call it a fair use. Fair use is actually a very technical term, but first thing I want to say is that it's a defense. You can't up front go and say, "Well, what I'm doing is fair," because it's a limitation on a copyright holder's exclusive rights, and it's basically saying that they have the exclusive right to copy something or reproduce it or assign the license to somebody else to do that. And fair use is basically, it's a limitation on that exclusive right. And it exists because if there was no if you had to wait to get a license every time you wanted to use, a copyrighted work, there wouldn't be any, new expression out there because everything builds on something else in some way. And so it's the courts have said that it's a guarantee of breathing space for new expression within the confines of copyright law. And it, carves out a space for creative uses, even though they're already protected by copyright. And like I was saying before, it's really hard to pin down because there is no bright line rule. You have to wait, and basically to claim fair use, you have to wait until you get sued, and it's whether it's fair use depends on specific facts of each case, and unlike plagiarism, copyright infringement doesn't depend on whether you give credit. Like, you can give all the credit you want, and if you're infringing, it's still infringement, even if you list where you got it. And the court will figure out whether they decide that your use of the copyrighted subject is fair by balancing 4 factors that are listed in Section 107 of the Copyright Act. And those 4 factors are the purpose and character of the use, which is, I guess we'll go through each of these individually. The nature of the copyrighted work, whether it's factual, whether it's more creative, the amount and substantiality of the work that you use, basically how much of the song did you copy for whatever you're using, and also what is the effect of your use on the market for that product? Like, how have you affected the market? And so the first of the 4 factors, purpose and character, the 2 parts of it are its transformative quality and whether it's commercial or not. Is the new work the same as a copyrighted work, or have you transformed it in some way, like using it in a new and different way, making it for a different audience? And also, will you make money from the work? Is it intended for like nonprofit or educational or personal uses, or is it made to publish and to try to sell and make money on it? So commercial uses can still be fair uses, but the courts are much more likely to find fair use if there's no monetary, if it's not financially, what's the word I'm looking for? If it's not a commercial venture for you. And then the nature of the copyrighted work, it's like, for that factor, the courts look to see whether that work is factual or creative. So like, if you're using parts of a dictionary or parts of a factual work like a news report and then transforming it and using it for a different purpose, they're much more likely to find the use to be fair than if you were to say, copy full parts of a story out of a book and like make something exactly like the thing you're using, the thing you're copying. And so if the thing that is created is, the thing that you're copying is more creative than it is factual, the courts are more likely to not find it's a fair use. The amount of substantiality of the work, so copying nearly all of the original work or copying its heart is going to weigh much more against if you just copy a little piece that's maybe not recognizable. Like if you're working on music, it can be a fair use. Sometimes if you only use a little piece and like use it in a very transformative way. So when the court looks to see, how much, figuring out how much is too much depends on the purpose of the copier's use. And for example, parodies, may need to make extensive use of what they're parodying in order to get the actual parody across. So they get more room. Something that's parodied, something that is a parody gets more room from the courts for what's considered fair use. And then effect on the market is basically how are you affecting their ability to make money on their copyright. The questions come into even if it's given away for free, you may be affecting their future rights to license it. If you use a copywork in a way that substitutes for in the original market, then that's going to weigh against fair use as well. But if the thing that you are creating with a copyright has a vastly different market, then like that'll weigh more in your favor. And there is an easier way to think about fair use, because that's not always easy to think about. It's a lot of factors to think through before you start using copyrighted materials. But there's the Center for Social Media and Washington School of Law at American University have sponsored the development of a lot of fair use best practice statements, and they kind of make it easier than ever to know what's like fair and how to use it. And they follow recent trends in court decisions, and they've collapsed the fair use factors into two questions. And basically the questions are, is the use you want to make of another person's work transformative? Does it add value, and does it repurpose the work for a new audience? And the second question is the amount of material you want to use appropriate to achieve your purpose? Are you using more than you absolutely have to? Like, are you using as little as you need to in order to transform the work in the way that you want to? So some purposes that are almost always found in favor of fair use are criticism and commentary, parody, and news reporting. For instance, the famous Kennedy assassination, the Zapruder footage, was put. Still shots of that video were put into a book called 6 Seconds in Dallas, and the owner of the footage sued the book publisher for copyright infringement. And the court found that the use of the stills was fair and reasonable, in part because the use was based on a factual and historical news event. For like parody, for instance, Family Guy, the popular cartoon, made fun of Carol Burnett's image and signature characters, and the owners of the copyright for the Carol Burnett variety show sued Fox, and the court ruled that the show's use was fair, in part because the episode was designed to parody Burnett as a public figure, and also using a relatively small percentage of copyrighted material, and that it wouldn't substitute for the original. So nobody's going to decide to watch Family Guy's episode about Carol Burnett instead of actually watching an old Carol Burnett show. And another example of news reporting was like the Washington Post used a few years ago used quotations from the Church of Scientology, and as most people know, the Church of Scientology is a very litigious group. They will sue you if you say something bad about the church publicly. But the court found that the use of the 3 brief quotations from their copyrighted texts were fair because the newspaper exerted only a small portion of the work, and the purpose was for news commentary, and that was in 1995. And so, like, what is criticism and commentary? That would be like quoting a few lines from a Dylan song in the music review, or summarizing, like, from a medical article in a news report. So the news will, like, read a big, hopefully they're doing research, and read some journal articles, and then report on, like, the new scientific information that's come out. And that's not considered copyright because it's for news and commentary on the thing, and they're only using as much as they need, usually the abstract, to kind of relay the information. Let's see. Parody, like we were talking about before, it's a work that ridicules another usually well-known work by imitating it in a comic way. By its nature, parody, like I said before, needs to make a larger use of the work in order to get the parody across. And see, news reporting, like, you don't even have to be transformative with the use if it's a newsworthy purpose, and as long as you're not trying to supplant the copyright holder's valuable rights, but are rather trying to deliver newsworthy information to the public, that's going to be considered to be a fair use. There are some other exemptions. Fair use comes from Section 107. Section 108 creates some copying exemptions for libraries and archives. And then Section 110 creates a blanket exemption for display and performance of work in like face-to-face teaching. Exactly, it says that performance or display of a work by instructors or pupils in the course of face-to-face teaching, in a classroom, and the performance or display of individual images is given by means of a copy that was like, so as long as the copy they're using in education is legal. If you recorded something off of TV and then bring it in, that's not a legal copy, so that you wouldn't get the education fair use or the education exemption for that. But as long as it's anything, and this is other than audiovisual works, but yeah, sorry, it's legalese, and I shouldn't be reading it to you right now like that. It's similar to, what's the case of motion, make sure.
Which one are you on, the second point?
Yeah, it's so basically what it reads exactly. Performance or display of a work by instructors or pupils in the course of face-to-face teaching, in a classroom or a similar place. Basically creates an exemption for people in face-to-face teaching, unless it's a copy that was done, that was made illegally. And then there's a more limited exemption for transmission and display of still images, but there's no exemption for audiovisual transmissions of dramatic works. So there are some, I know I've had a lot of teachers that probably weren't under the education exemption, and some of the things that I was shown in videos in class growing up. Various fair uses that have been found over the years. In terms of art, there have been many artists that have been sued for copyright infringement for using photographs of somebody else as part of their artwork. There was American artist Jeff Koons used a portion of a designer photo advertisement. It was a model's legs and Gucci sandals, and he used those images in his painting, and the court held that his use of the images was transformative, in part because it commented on fashion and consumer culture. And let's see, there was publishing part or putting part of somebody's unpublished letters in a book was considered fair use because the author put less than 1% of the unpublished letters in the book, and it was for the purpose was to educate and inform the public about the person the biography was about, so that was considered a fair use. And a researcher at a nonprofit foundation used quotations from an unpublished literary work in her academic presentation, and they found that that was fair because it was used solely for the purpose of scholarly analysis. And like other things like time shifting is when back in the days of VHS, if you recorded something on TV, so you yourself personally could watch it later, they found that that was a fair use for just time shifting you're just changing the time when you're watching the video that you already have a licensed agreement to watch. DVRs have kind of moved past that now since most people don't have to deal with it. And search engines have been given fair use because when they have little things that pop up, it's the Google search engine when it does photos, and it turns up the photos on subscription-only websites. The court still ruled that Google's use of the thumbnail photos was highly transformative because the search engine changed the image's original purpose of entertainment aesthetics into providing Google's users with images or links to images. Since they were just thumbnails, the court found that was a fair use because they weren't using it for the same purpose as the owners of the copyright. But again, what I want to say is that it's a defense. It's not something you should necessarily count on. So especially if you have a way to acquire the license of the copyright owner, you want to try to do that, if at all possible. it's complicated to go through every time. The courts look at, on a, like I said, a case-by-case, specific, like fact-specific basis, and it's a tricky line to toe sometimes. And I think that is the end of our presentation, and we would be glad to take questions because I'm sure that you all had some specific questions at least coming in, and hopefully we've answered some of them, and we will gladly answer any others you have.
So you mentioned trends in copyright decisions in courts, but obviously something like people downloading movies, or while it is an infringement technically, like there's probably not like a governor's task force to crack down on. I mean, maybe there is, but what are the most typical instances of things that end up in court over copyright? Is it mostly like
Lately there have been a lot of actually. Oh, right, the mic question. Yeah, and repeat the question. So the question was, what have been a lot of the copyright cases that have been showing up in court lately? And over the past 6-8 years, there's been a big rise in, copyright movie download cases or like music download cases. Especially very recently, there are lawyers or attorneys or researchers that will go out and search, BitTorrent or other internet spots for downloads, and they will file a lot of cases just against all the IP addresses that they found are downloading their copyrights, and then after doing that, then they subpoena the court for the internet provider to then give them the names and addresses of the IP owners. So those are a lot of cases. A lot of times those actually settle before.
I'll give you one that is currently working its way through the court now. I mean, maybe even as recently as last week. So there was a movie that came out about a few months ago, put out by the music group NWA, straight out of Compton. And so currently their manager, or their original manager, has filed a suit against them for copyright infringement, suggesting that a lot of the work that is presented in the movie, he has protections on based on a book that he already published. So some of the stories or some of the imagery or scenes in the movie, he's saying is basically lifted out of a publication that was, and I mean, straight out of Compton, I think made like over a couple $100 million in the theater recently. So the suit is worth, at least it's asking for over $40 million. So that's something that's more likely to happen. So if you're creating work, in this instance, he probably published a book that very few people cared to even read or purchase. And it was some time ago. I don't know how long ago, but it was not recent at all that he published that book. There's also a lot of instances wherein other folk who may write an autobiography, for example, not knowing that they would, or I won't call it an autobiography, I'll call it a journal. Not ever knowing that they may become famous later on, or at least a person of notoriety later on, and maybe a family member or someone else will stumble on that and figure out a way to cash in on stories about you. Hey, look, I've been friends with this person. I know this person for 20 years. Maybe they don't mind that I can tell the intricacies and the behind the scenes tell about something that pertains to their life. Well, it's interesting to note that copyright protection lasts for an awfully long time. In fact, it exists even after the person, the creator, deceased. So, once you're gone, it's a right that you could pass on to your heirs.
In terms of downloading things off the internet, that is a large part of the copyright cases that we see now. There are a lot. I mean, there are, numerous. It's like I said before. It's usually off of BitTorrent, and there have been some people call them copyright trolls, but there are law firms that are set up to they have agreements with the the rights owners, or they are working on behalf of the rights owners, and they just go out looking for people that are downloading it and just suing for copyright infringement in mass numbers. A majority of, a lot of people, not a majority, sorry, but a lot of people settle, and the people that settle ahead of instead of going to court, we don't know how many people there are because they settled before going to court. So the large number of cases are just the ones that are recorded or are fought at least long enough to get to that point. But it's definitely something you want to be careful of, and I would not recommend downloading, movies or music unless it's through a verified source that you're paying for to, from the people that actually own the rights of that movie.
Does YouTube constitute tangible form?
Does YouTube constitute tangible form? The original tangible form, like if you upload something to YouTube, the original tangible form is the original recording you made, whether that's on your phone or your camcorder. The problem with YouTube is that by uploading it, I'm sure that Professor Hedges would know more about this than I would, but you are giving YouTube the right to, have it show it and allow lots of people to see it. They're basically publishing it for you in a certain medium, and you're agreeing to do that without them paying you necessarily. Although they have set up, I don't know, YouTube. I don't really use YouTube for that purpose, but
The underlying tangible
Yeah.
there is the hard drive or the server or whatever that's actually storing the video. That's the tangible medium. Think of, like back in the day where they used to be the roll of film, rather than being a roll of film, which is a tangible medium in itself. Now it's a hard drive or a server or some sort of computer, memory that is the tangible medium. It's something that's fixed. It's a physical, tangible way of storing the work.
So when you copy a file, because you're moving it from one tangible form and you're copying it onto another tangible form, another hard drive, you're doing the essence of what copyright infringement is, which is copying or reproducing. So, yeah, please.
I think like after 60 years or something, the creator is deceased. Does a piece of work become, or what's the difference between public domain or fair use?
The copyright is good for the life of the author plus 70 years. So 70 years after the deceased date, that work will fall into the public domain.
So and that is fair use.
Then it's fair
yes.
use, yes.
At that point in time, you wouldn't even need to rely on fair use because it's in the public domain.
Okay.
There would be no underlying
Is it not
infringement.
Yeah.
So
Yeah.
you don't even need the defense of fair use in that situation because it's part of the public domain now and you can go ahead and use it. And there are distinctions there too. It's if it's not a work for hire, it's called it's the life of the author plus 70. But if it is a work for hire, then I think it's the 75 years. So there are slight differences there as to when it actually expires. And there are like 3 different copyright acts, and whether or not it's part of the public domain kind of depends on when it was created or even published. So it can get kind of complicated really quick. But generally speaking, what we're referring to here is the Copyright Act of 1976. So that's kind of a cutoff there as to when these new rules come into place. Some of the earlier rules are much more forgiving that actually required registration in order to maintain the copyright or even renewal. So a lot of the photos and that sort of thing, that if it wasn't renewed or re-registered, the copyright is expired. But that was under the pre-existing statutes that existed. So it really kind of depends on when the work was created as to whether or not it's expired or not. I think we call it the Disney extension.
Right.
That a couple of years ago, Disney successfully got through Congress an extension of that term because some of the original Steamboat Willie Mickey Mouse copyrights were about ready to expire, and they were able to extend that on. And there was even a court challenge saying, hey, you can't do that. The Supreme Court said, you know, for a limited time, in an extra 25 years, or whatever it was, is a limited time, so that's fine.
Along with that, generally speaking, when people talk about the public domain, it usually goes alongside of what's called orphan works, wherein people may perceive something to be in a public domain because it may be very old, unregistered work, is not required to be registered, but people maybe not even have kept records or whatever, but we don't know or cannot identify who the rightful owner of that even was. So oftentimes, people that's looking for commercial value would shop around for orphan works, which is works that nobody knows who even created this stuff to begin with or who has the rights to this stuff, or things that's in the public domain, which are anything probably before like 1923 at least would be in the public domain for sure, right? And then they start to make volumes of those type of things. So like really old music, you know, maybe classical music, I don't know, maybe like really old publications and such. And then they'll try to figure out a way to get a copyright themselves, not in that original work, but in the way they present the work. So for example, like a recipe book is a good example, right? So a recipe cannot be copyrighted, but the order in which you decide to put those recipes in the book, you could get a copyright in, if that makes any sense. Like the order by which I present the material and stuff could be protected, not the actual recipe.
I have a question kind of about how much the common person should worry about infringing on copyright. For instance, I work downstairs in the Digital Creativity Center, and a lot of people are creating projects that they'll put on YouTube or on their Facebook page. If you, for instance, use a photo in the background of like on a green screen, like if you put yourself in front of someone's photo that they created, is that transforming it enough to protect yourself? And could you just talk a little bit about transforming artwork and how much you need to do? I mean, I know it sounds like I'm trying to get away with something.
Yeah, that is a fair use question. Basically, the question was when you're making things for YouTube and you're using somebody else's work, like for instance, a photograph on a put it up on a green screen behind the person, so you're kind of acting or performing in front of this other photo. Like all the factors that we had before are gonna come into play. Part of it's gonna be I'm gonna bring those back up. The 4 factors.
So we just had this in whole, for example.
Yeah, and so it's gonna be like, what was the use originally used for? Like, are you presenting it then in the same way? Like, if it was an advertisement photo, is it still kind of an advertisement photo? And like that's the nature of the work and like what you're doing with it, why you're using it. It's going to be really helpful if you're not making money off of it. And then also I know that YouTube wants to indemnify themselves, and so I'm pretty sure they make you like click on an I agree for anything you upload saying that you have all the rights in it, or if it's not, then they've started doing it with music, I believe, where you can actually use other people's, I think, but then it goes through the same, like it's basically like a hit for their official music video, I think, but you'd have to read the YouTube. I don't
I have a
upload
question.
things.
What is the image of that you have in mind?
Well, the most common thing is nature photos or like artistic photos that, like, say somebody wants to pretend like they're in a field of flowers, and so they find like a really pretty field of flowers, things like that. But then there's all kinds of different things, but it's usually just for fun.
If it's being artistic, I mean, a lot of times with YouTube, like if the owner of it sees it, they're going to send you a cease and desist letter, and if they do that, just take it down. But it's just that it's, if you're not commercializing it and it's like for personal use, like that's not a big deal. Like the issue of publishing it on YouTube is trickier, and I haven't actually worked on any cases that dealt with that. Professor Hedges? Yeah, sorry.
The lawyerly answer is it depends.
Yeah, it really does depend, because I'm thinking maybe perhaps, and it invokes in my mind like a poster company. Maybe a poster company, their business is just providing posters. They want to get you to buy them posters. Though they may get those images, it may not be something they created themselves. There may be a vendor out there that have generic type photos that they don't really, they themselves have the protection in, right? So they probably gave the poster printer or whatever permission to use that image for the purpose of creating posters. That person didn't actually go out and create the photo themselves. But in some cases, there may be images out there where a person who is just wants to make images for fun and don't really care who uses their images. And they may have had a data bank of their photos that they say, hey, look, anybody in the public that want to use this, go ahead. And they may have gotten a picture from them, and so basically the point that the reason why I'm explaining that is that when I talked about the bundle of rights earlier, you could only pass on what rights you actually own. If you don't have a right, then how could you enforce something? For example, the mention was about YouTube earlier, talking about the internet. Well, in some internet websites you go to, they have disclaimers in terms of use on the bottom. And if you click on it, it'll say something along the lines of, hey, look, this is what we're allowing you to do. If you use this, that does not mean that you own what it is that you use our site for. We're allowing you to have free access to this for your own personal use, but not to commercialize.
And I think the best answer is, and John alluded to this earlier, is that fair use is a defense. So the first thing you want to do is try to avoid the need for the defense in the first place. So if you're looking for a picture of a field with pretty flowers in the background, go out and look for one and see if you can't find one where it's free. It's a freeware situation, or it's part of the Creative Commons and it falls within under that agreement. If that's the case, use that one. They've already given you permission to do it, so you avoid the whole fair use issue to begin with. If you can't do that, or you forget to do that, you find yourself in need of the defense, then it's going to come down to the factors that John mentioned. If you just post this YouTube video on there and you're just goofing around and your only people are looking at it are friends and family and that kind of stuff, and you're not getting ad dollars for the number of clicks on your YouTube channel or whatever, you know what? Probably non-commercial. Did the guy lose any sales as a result of this? Probably not. So it's going to go away. But if you're doing this because you have a series of videos on there and people are coming to your channel and you're doing this for revenue generating because you're getting clicks because of the advertisers that you're drawing in there, well, that's starting to look an awful lot like a commercial enterprise. And if it happens to be that the photographer that took these pictures, his business model is licensing these images for people to use as their background, well, now you are taking potential revenue from that party. So it starts to look an awful lot like it's not really fair use. So the answer usually is try not to even get to that point where you have to rely on it. Go find, I like to put, little images in my PowerPoints and that kind of stuff. And if I find an image that I like, I try to find it from a freeware source or a clickware or where it's free. So I don't have to deal with fair use. Even though I'm an academic and I'm using it for academic, I don't even want to go there. So basically, issue avoidance is usually your first step in the process.
I have a screenplay that I copyrighted, and I was told that even though it was my copyright, it doesn't hold water if I don't register it with the Screenwriters Guild in California. Is that true?
I don't think so. there may be some situations in place there that maybe the Screenwriters Guild won't, let any of their licensed professionals work on your play unless it's registered with them or something like that. But that's really more of a contract issue. It's not a copyright issue. Somebody couldn't take your screenplay and just copy it verbatim if it was not part of the Screen Actors Guild, list of things. I'm not aware of an exception for that. Yeah, so I don't think so.
I play rock music, classic rock of the 60s, 70s, and 80s, even the 40s and 50s. So I play it with drums more frequently, so almost every day. So, and I download it to my iPod. So, and is it okay?
So you're doing this privately. You're playing it in your house, and you're recording yourself playing it rather than being out in public and performing it. And is that the right scenario?
I play drums along with music, so with song, with a performer on for instance, rock classic on the CD. So I play along with that, and I played Leonard Beasley's drum show on Cats TV years ago. So.
But it's for your own. It's it's a private thing. You're not out at a bar or a venue playing this publicly. And
Not in a bar at all.
Yeah,
no.
yeah. So that situation, if it's a private performance of the music that you're recording yourself, you're probably okay because it's not a public performance.
Yep.
And the fact that you're making technically you are making a copy of the underlying work that you're playing along with. But it's probably a de minimis situation where you already have the underlying copy. It's not like you're taking the one copy and then passing it along to somebody else, and now there are two copies out there that two
No.
people are different using. You're probably okay in that situation.
Yep, and I play drums at home, so I play drums at home, and of course I play drums in the studio sometimes.
Yeah.
And most likely I play drums at home. I play along with a CD, and I download it. I'm making 100 songs per year, so
And it's for personal use, and you're not turning around and selling it and that sort of thing.
it's not selling it at all.
Yep.
Because I'm playing it for Cats TV.
So again, it kind of gets back to the whole, are you commercializing it, or is it kind of only for personal use and that kind of thing? So you're not stealing sales basically from the original copyright owner in the situations. You're probably okay. But if you start talking public performance and that sort of thing, now you're into a whole different arena, and that's you're somehow being compensated for your public performance, and it starts looking an awful lot more commercial and that sort of thing. So it becomes becoming an issue.
I think there's a caveat with that, like if it's one of those groups that's advertised as like only doing like, for example, like the only Metallica song, like
A tribute band.
cover band,
Yeah.
tribute band, something like that. Then I think they just look at performance rights.
Yeah. Right.
Well, Lennon is a prolific producer here at Community Access TV station downstairs and in our Digital Creativity Center. And Lennon, you put a lot of these on YouTube, right?
Yes.
So is he okay with with putting it on YouTube?
That starts getting a little trickier. In that again, it gets back to the YouTube example. If people are using that copy now as kind of an alternative source to the original copyright owner, then you're starting to pull sales away from that original copyright owner, and you're diluting or diminishing his ability to sell his copies. So you're starting to get in there, and if you're getting any hits or any revenue off of that, starting to look commercial like and that sort of thing. So yeah, you're starting to get into that dangerous territory there, because again, you have to think to yourself, are you somehow harming the original copyright holder in doing this? If you're just playing it at home, performing at home, you're not. But if people are going to your YouTube site to listen to this underlying recording, this music that's going on there, and not purchasing or going to a subscription source to listen to that music, and that guy's not getting royalties off of it, and it's starting to look an awful commercial-like, and you're harming essentially the copyright holder.
Yep. And one thing, I always play it at home, and then edit it and then put it on Cats TV, on Let It Easy's drum show.
So it's finding its way out into the public through this Cats TV. So I would tread lightly.
Yeah, so with some, for example, opera type music, I don't know exactly what it's called, but I don't know the fancier type music. Sometimes the performers who are just vocalists, they'll actually get an agreement. They'll pay to use the music, so they have the background music, and then they'll perform as a vocalist. But then they still get performance rights and the sound of their voice. Although they don't, but that doesn't mean that they have right in the actual other people's music.
Yeah, that's a good example that Gerald gave, that there is a market for the use of songs as background to maybe what is considered the primary performance there. If you have an opera singer using this background music, well, that is an avenue or a chain of commerce there that the original copyright owner is now losing out of if the opera performer did not have the license to
Right.
do so.
So with music, sometimes it gets a little bit tricky because there's the copyright not only in the recording itself, the actual sound. Like, so if you were to, copy the CD and use that actual music in the background of whatever you're creating, then you're using the copyright in that sound recording. And then there's also the copyright in the composition, which is the actual, written notes on the composed song, like the notes on the bar. And so, if you go out, or like he was talking about, like cover groups, or and you record your version of doing that song, and then you, let's say, burn on a CD and sell it, there are actually there's statutory fees you're supposed to go for every one sold, and there's a standard fee, and you're supposed to register that with, do you remember the name? Sound Exchange? Yeah, record that with Sound Exchange. And so if you're actually selling and commercializing it in any way, there's a standard way to basically pay the songwriters. And so that's why it's always a big deal when bands are working together, when they decide whether the songwriter officially is always going to be all of the band or just the person that records it. Because if the band gets really big, then the whole band is going to have copyright in the sound recordings because they're the ones that are performing on the actual records. But only the person that's registered as having the copyright in writing the song will get that half of the promotion. And so it's with music it's really tricky. So it's, if you're using a copyrighted work, the best, I always recommend, if you can ask for permission, I would. If there's a person that clearly has the copyright to it, then fine, they will license it. There are standard use fees if they're going to be publishing something. But
I like to err on the side of caution, and when it comes to situations like that, using someone's music, just ask yourself two questions. Is it a copyrighted work? Did I copy it? And if so, you have those two elements of infringement.
Sorry to ask such a silly question, but I recently heard that the Happy Birthday song is now not infringement anymore to play that on a movie or TV show. Do you know why that was? What was the reason
That's
behind it?
not quite true. It's the issue, underlying issue is the ownership of the song has come into question. So the party that for a long time claimed to have ownership of it, turns out that they didn't own it, and I think they're still trying to figure out who actually does own it. So the copyright's still around there, there's just a question of who actually owns it.
We're just kind of in limbo with the.
Yeah, I don't know if that's been resolved or not as to who actually owns it, but it's always shocking me that Happy Birthday is a copyrighted, piece of music, and it is.
And that is presumably the reason that, if you go to, Olive Garden, they don't actually sing Happy Birthday to you, they sing their own birthday song.
It could be. Yeah. Any other questions? Go ahead.
It seems like I've heard somewhere that a student's work, that it's partially owned by the school if it was an assignment. Is that true? Or can they actually sell that piece of work that they created as an assignment?
It depends. That's always a great lawyer answer, right? So it oftentimes depends on the employment status of the student. If the student is an employee of the university in some way, shape, or form, typically it's a grad student situation where the grad student is actually an employee of a university, then their employment arrangement with the university will dictate who owns the intellectual property, including the copyright in that. If it's an undergraduate student, undergraduate students typically are not in an employment situation, so the university typically would not own it in that setting. But every university is different on their intellectual property ownership clauses and policies. But that's kind of is a general rule of thumb. Undergraduate, university typically doesn't own it. Graduate or even faculty member, the university typically does own that because they consider that part of the employment. And regarding the assignment question, an assignment is really just a legal document transferring the rights in it from one party to another. So if John came up with a song and I wanted to buy his copyrights in that, he could assign me his rights in it, and then I would own whatever portion of this bundle of rights that Paul has been talking about, John has given me. It might be all of them, it might just be part of them, but through that assignment, this contract, the rights have been transferred from John to me.
Well, yeah, what I meant by an assignment was like, say in a fine arts class, your assignment is to, use this medium and
Typically in that setting, that's going to be an undergraduate situation that they're giving you an assignment on, and the undergraduate student's going to maintain the rights in that. But that's a very university by university specific question.
On the other side of that coin, aren't like faculty's published works in scholarly journals, those become the property of the journal, is that correct?
Depends on the rules of submission. If part of the agreement, if the terms of and conditions, if you give us a copy of this, you submit a copy to it, then we own it. If that was the term that you agreed to, then you're kind of stuck with it. I would be surprised if that's the way it worked for a lot of the journals. I don't know specifically, but it would not surprise me at all that by submitting it to them, you have given them the right to make a copy of your article in their publication. That doesn't mean that you've given over the right for them to publish it, all over the place outside of their particular journal. But it really only kind of makes sense that if you're submitting this for that journal, for publication, then it only makes sense that you give them the right to copy it. So that's probably what you're referring to.
But in the instance of faculty, like I actually had to write one of the perimeters for copyright for faculties for the IU University last year. So we added some of that. So even if the university has the right party agreement to do whatever they want with your work, the faculties would still get a percentage. So based on their contract. So yeah, and it actually might work in the faculty's benefit to allow them to distribute it more because you have an agreement that, hey, look, you're going to get a piece of the pie. Along with that, maybe even your department that you work under would get a part. That way, some of that money can go back into that department and add to the value of that department itself.
Mm-hmm.
But they want to get that out to as many people as possible because it builds the prestige of the university.
And there's this little thing called the faculty exception that most universities recognize. If you actually read the Copyright Act, that copyright would technically belong to the university because the professors are creating that work in the course of their employment, but they don't enforce it on professors, so most professors retain the right in their works.
And there's an academic freedom component to it as well, that universities, or at least faculty, don't want to be caught in the situation where they create a work, a publication like that, or an article for like that, and then they turn around and the university says, no, you can't distribute that because you'd be committing copyright infringement. You've got a you know, academic freedom issue percolating under there as well. Any other questions? All right, well, thank you for allowing us to come over and our students present. Did you have one more last question?
And maybe you could just explain what the intellectual property clinic, who it's available to, and
Yeah, so the Intellectual Property Law Clinic is a free legal resource that is part of the law school now. It's been around for unofficially a little over a year, officially since last fall. And it's basically a free legal service on matters of intellectual property that we make open to those of limited financial means. We don't want Bill Gates showing up looking for free legal services because Bill Gates can afford legal counsel. But basically, it's an opportunity for students at the law school to work with clients, putting into practice what they've learned in the classroom into real-world situations. Gives them an opportunity to work with real clients, the first couple of clients, under the supervision of people like myself and some adjuncts. I think collectively, myself and our other adjuncts, we've got like 50 years of experience in intellectual property. But that's what we do. We prefer entrepreneurs and folks that are startups and that sort of thing. But we'll entertain work from anybody if it's got a legitimate purpose. So great. Again, thank you. And this was part of the course. I want my students to get experience in doing public speaking and fielding questions on the fly and that kind of stuff. So thank you very much for that. John, do you have one last thing?
Yeah, and I would think that we would be happy to take on, if there are cease and desist letters for copyright issues for people that would, want at least a little bit, of, or need like lower cost free, at least consultation on that issue. That would be something that would be interesting to come through the clinic.
Yep.
So.
Great. Again, thank you very much for the opportunity.